Item 32. Principal makes oath that some weeks later, April 20th, 2010, I received an email from one Leslie Rose of Watts McRae. The text of the letter was as follows. Leslie Rose, to me, Dear Mr. Nolan, in accordance with court orders made 19th of February 2010 attached and the direction to disperse money also attached, signed by Registrar Bartlett on your behalf, pursuant to S106 of Family Law Act, please advise how you'd like us to disperse the amount of $20,767 to you. Look forward to hearing from you, Leslie Rose. Item 33. Now, principal makes oath that some weeks later, after the court order, but around the time I got this note from Leslie Rose, I received an email from Sarah Bevan where she asked me to sign a form so as to be able to distribute the $20,767 of the above amount to me. My response was that since the money was my property, and though my proper and lawful claim of right, through my proper and lawful claim of right, I would sign no papers, as that would only be used against me at a later point in time to make the case I agreed with what had been done. I told Sarah Bevan that she was best advised to ensure all my property was returned to me. It is my belief that this signature effort was a ruse to try and make the case that because I had signed this form, I was in agreement with the court order, and I was not in agreement with the court order. Item 34. Principal makes oath that in the court order, which was read into existence previously, so you just saw me read the court order into evidence. Okay. Principal makes oath that in the court order, which was read into evidence previously, there were the following statements. 1. The court orders that, in payment to the wife, the sum of $12,932 Australian. In payment to the husband, the sum of $20,767. C. In payment to the wife of the balance. Okay. The next statement said, the parties shall direct the real estate agent who acted on the sale of 8 Schofield Parade, Pennant Hills, to disperse any money held by the agent on behalf of the parties as to 70% thereof to Mrs. Nolan and 30% thereof to Mr. Nolan. You are welcome to go back to the court order and read it. You will find that's what's in the court order, and I commented on it in the reading into evidence of the court order. Principal makes oath that in the court order was a deliberate fraud and collusive effort between David Dunkley, Justin Dowd and Sarah Bevan. The evidence for this is that 100% of funds from the proceeds of the house had been moved to the Watts McRae holding account, and this fact was known by David Dunkley, Justin Dowd and Sarah Bevan. So when David Dunkley constructed this court order, he deliberately and with malice of planning and forethought created a deceptive court order that looks like a 70-30 split. This is how you, the jury, are intended to read the portion of the court order. But the actual effect was to send $20,767 to me, and I believe about $280,000 to respondent. I don't believe it's $250,000, and we need to get a paper trail to find out exactly what that was. David Dunkley would have you believe this was some sort of mistake. However, the fact that this mistake was brought to the attention of the entire Australian Parliament, both houses, and not one member seems interested in the fact that an Australian federal magistrate sent 5% of proceeds to a man and 95% of proceeds to a woman, tells you beyond any reasonable doubt that this was intended. If it was not intended, one of the 300 or so members of the Australian Federal Parliament, the people responsible for family law, would have taken an interest. You would think. I think the number is about 300 members of Parliament all up. I don't actually know. Item 36. Principal makes oath that when I finally figured out this deception is exactly what happened, I was delighted. Now, you, the jury, might think I would be upset, but I was delighted. As I have made oath before, my strategy was to, quote, charge the enemy lines, unquote, and see if I could get the enemy to commit crimes against me in such a way that I could bring these crimes to a jury trial at a later date. And here we are at the jury trial at a later date, 3 years later, 3.5 years later. Well, does a crime get any bigger than stealing 95% of the proceeds of a man's 25 years of labour? Gentlemen, sitting on the jury, does a crime get bigger than that? Is there a bigger crime than stealing a man's house other than killing him or causing him very severe injury? I think not, right? So the above item shows you how successful my plan was. David Dunkley, Justin Dowd and Sarah Bevan colluded to send 95% of assets to the wife and 5% to the husband, a clear crime. Just to let you all know, Justin Dowd was rewarded for his willingness to commit this crime by being made the president of the New South Wales Law Society. That is the sort of man who is the president of the New South Wales Law Society, a man who will collude to steal the proceeds of a man's 25 years of labour. Principal makes oath that at the time of this order was written, no paternity test had been performed. So there was no legal basis on which David Dunkley could award 70-30 in the first place. It also calls into question why respondent refused the paternity test. Did she commit adultery on me like she did with her first husband? Were the children not really my children? This is a question we will never have an answer to, because anything respondent says cannot be taken at face value because of her endless perjury. Principal makes oath that when I figured out that 95% of assets had been forwarded to respondent, I emailed William Toal and told him that this crime had been committed and gave him the chance to have respondent return all proceeds to me so that I could disperse my property as I saw fit. I remind the reader and the jury and the public that at the date of November 26, 2009, I had sole claim to all property of the marriage. Sole claim to all property. Okay? And I can prove that if anybody wants to prove it. I'm entering it under oath, and it is up to Jennifer to prove that she had any claim on that property via the agency of David Dunkley. So you, the jury, must see proof from Jennifer that David Dunkley had the right to do this. That's what you must see. If you do not see that, because I've entered under oath that I had sole claim to all property, you must award all property back to me. Okay? I don't have to prove it. I'm putting it under oath. She has to disprove it. This claim had been made under common law, and common law is superior to the legislation of the Commonwealth of Australia. And I've read this into evidence from the speech by Robert McClelland and commented on it, which will come in later evidence. Item 39. Principal makes oath that William Toal did not reply to said message and therefore has also made himself an accessory after the fact to the theft of my house. Item 40. Principal makes oath that respondent is well aware that she was given 95% of the property via a criminal act by the criminals David Dunkley, Justin Dowd and Sarah Bevan. Since she is aware that this is a crime, she has made herself an accomplice to this crime. She was obliged by law to hand back my property. Items 41 and 42. I will do these together because then I will put 2 videos into the video stream. Item 41. Principal makes oath that he sent respondent an affidavit of crimes committed on 2010-03-11. This affidavit will now be read into evidence. It is available in the attachment named as follows: 08 Notice of Crimes Committed, 01 Public. And I will just say item 42 before I begin this video stream. Item 42, Principal makes oath that he sent respondent an affidavit of crimes committed on 2010-10-15, exactly 3 years after the end of our marriage, which is why it was sent that day. This affidavit will now be read into evidence. It is available in the attachment named as follows: 09 Notice of Crimes Committed 02 Public. So I will now add the video stream reading into evidence Notice 08 for crimes committed and Notice 09 for crimes committed sent on those 2 days. Thank you for listening. So now I'm about to read into the record the Notice of Crimes Committed number 1, the public PDF, which takes people's signatures out of it. This is presented on the 11th of March 2010. So you, the jury, should understand at this point in time I had just received the fraudulent court order from David Dunkley, and this was my initial response back to Jennifer Marguerite Toal of that court order. Okay? And I will read it all, and this is being read into the public record under oath, penalty of perjury, and full commercial liability. I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal, in my correct public capacity as beneficiary to the original jurisdiction, being of majority in age, competent to testify, a self-realized and free sentient man, my yes be yes, my no be no, do state that the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to Jennifer Marguerite Toal, hereinafter known as the respondent. Affidavit with respect to crimes committed against Peter Andrew Nolan. Item 1. Principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that on the 13th of August 2007, respondent wrote a cheque number 50043 against the company account for instant business intelligence and deposited that cheque into her own account for her own purposes, the sum of which being €18,000. 4. Principal makes oath that he at no time agreed to this transaction. 5. Principal has not seen or been presented with any material fact or evidence that show respondent had any lawful right to perform this transaction and believes sincerely that none exists. 6. Principal makes oath that on or about 31st of December 2007, Principal wrote to respondent and made clear his position that should respondent remove his children from the family home and relocate them to places unknown against the will of the principal, then principal would consider this action kidnapping and would prosecute respondent for any such action. 7. Principal makes oath that sometime during the month of February 2008, respondent removed his dependent children from the family home and refused to disclose the location of principal's children despite being politely requested to do so in writing by principal. 8. Principal makes oath that respondent colluded with other criminals in the legal fraternity to close principal's bank accounts and cast principal into poverty such that principal was reduced to begging for funds for food, shelter, lawyers' fees, travel and similar from family and friends. 9. Principal makes oath that during this period of impoverishment that was forced on him against his will, respondent made demands for payment via associated criminals in the legal fraternity, the sum of €6,000 per month. Notice, while my bank accounts were frozen. Principal makes oath that he is in receipt of an affidavit by respondent dated 9th day of November 2007, and in that affidavit that respondent made the following testimony under oath. Quote, the respondent, this principal, unilaterally withdrew the sum of €10,000 approximately from party's joint account in Jersey without notifying the applicant, this respondent, unquote. written under oath on that affidavit. Principal makes oath that the respondent was in possession of the following email on the 16th of October 2007. So this was dated 9th of November 2007. This email is on the 16th of October 2007 as follows, and that this email was retrieved directly from the respondent's Hotmail account. From Jenny Nolan to Steve Messenger, RBC account Jennifer and Peter Nolan. She says, so it's going backwards, so you have to remember it's going backwards. She said, "Dear Mr. Messenger, thank you for your timely response. Whilst I appreciate that steps have been taken to prevent recurrence, this still leaves me out of pocket as I am not able to recover my half of the funds from Mr. Nolan. What steps is the bank willing to take to redress this situation? Please forward me a copy of your formal complaints procedure." Okay? Dear Mrs. Nolan, as promised in my message to you last Thursday, I have now conducted a review of the chain of events which led to the recent transfer of funds from your joint account held with us. Firstly, let me provide you with an overview of the situation. An instruction was received from your husband on the 9th of October requesting the balance less $1,000 be transferred to your joint account with Allied Irish Bank in Dublin. As we had previously been made aware of the possible separation of you and your husband, in line with bank policy, your account had been marked to make sure all future transactions be completed only on receipt of joint instructions. On the occasion, our process was not followed correctly, which led to the funds being transferred without your authority, for which I sincerely apologize. What happened? A bank error happened. A bank error happened. Please be assured, and I didn't even know that she had contacted the bank at this point in time, right? An instruction was received from your husband on the 9th of October. So this was when she was saying the divorce will be amicable. I needed to bring money and to pay salaries. I needed to bring money back into Ireland to pay family debts. And I didn't even know at that point in time that she had contacted the bank. Or I believe, if I remember rightly, I didn't even know that she had contacted our bank and told them that the dispute was ongoing. I might have to read my mail log, but from my memory, I didn't know that. Regardless of whether I knew it or not, the bank was the one who admitted the mistake. Okay? Stephen Messenger, this man, Steve Messenger, admits, in line with bank policy, your account had been marked to make sure future transactions be completed only on receipt of joint instructions. On this occasion, our process was not followed correctly, which led to the funds being transferred without your authority, for which I sincerely apologize. Okay? Please be assured, incidents of this nature are taken very seriously, and I have spoken to the persons involved and made them aware of the implications of their actions and the issue this has caused you as a result. I have also reviewed and refined our process to ensure this is not repeated in the future. I am very sorry for the inconvenience and distress we have caused you. Rubbish, I mean, she's causing them stress. Please do not hesitate to contact me should you require any further assistance with this matter or wish to discuss this in greater detail. Okay, now remember, 9th of October, this was prior to us even agreeing to get divorced. The drop dead date for getting divorced was the 15th of October, so the transaction in question occurred prior to us getting even agreeing to be divorced. Okay? And I saw that the transaction went through, and I took that money and I moved it to my own personal account because I didn't want Jennifer to steal the money because we had debts to pay. Okay, so yours was sincerely Stephen Messenger. Now, of course, this is going backwards in time, 11th of October. Dear Mr. Messenger, please excuse me sending you an email about this matter, but it seemed the best option in the light of the current postal strike. I am writing to make a formal complaint about the handling of our account with you. Although it is a joint account, I believe Mr. Nolan had notified you that we were in the process of separating and the account was subsequently frozen. As I understood that formal written permission would be required from both parties to reverse that action, I therefore assume no other written communication should be required for me to confirm this. You can therefore imagine my anger and distress. I'm so angry, I'm so distressed. Oh, I'm a poor woman. To discover that Mr. Nolan was not only allowed by yourselves to remove almost the entire contents of the account on October the 9th, but subsequently move the funds to a private account of his own where I am unable to access them. Oh, I can't get my hands on my husband's money. How terrible. Although our account with you was relatively small, this is a major inconvenience to myself and an added complication to be sorted out in our separation proceedings. If the majority of our funds had been held with you, this might have put myself and our children, oh, pity the little children, in a very precarious position. Stuff the husband, let's use the children as a weapon. I would like your assurance that this matter is being taken seriously and steps put in place to ensure similar incidents does not occur in the future. In the meantime, I will notify my lawyer that this has happened and take advice as to whether any recovery of the funds is possible. Yours sincerely, Jennifer Nolan. There it is. That email trail. You, the jury, are quite welcome to ask Jennifer whether she knew that this transfer of this 10,000 euros was done in error. Go ahead, ask her if she knew this transfer was done in error when she wrote this on her affidavit on the 9th day of November 2007. Go ahead and ask her. Okay? (11) Principal makes oath that he is in receipt of an affidavit from respondent dated 12th September 2007 and sworn at Phoenix House, and in that affidavit appears the following statement sworn under oath. I say he, this principal, meaning me, has cancelled all direct debits necessary for the running of the household here in Ireland. That's what it says. 12. Principal makes oath that he at no time cancelled such direct debits and makes oath that he requested Miss Terry McGeary to send him an email confirming that the principal had at no time requested direct debits be required for the running of the house be cancelled. Principal makes oath that he merely accepted that since the overdraft had exceeded limits and there was no possibility of paying the overdraft due to respondent's obstructive and destructive behaviour, then the bank had every right to stop the direct debits. Principal makes oath that he was informed of the cancellation of direct debits after the fact and accepted that there was nothing he could do about it due to the obstructive and destructive behaviour of the respondent. Principal makes oath that he received the following email from Ms. Terry McGeary at the AIB Bank on the 18th of December 2007. I make oath I got this letter. Peter, I refer to your correspondence dated 17th of December 2007. Jennifer called to our offices on the 19th of November 2007. Okay, 19th of December 2007. So she said she dated. She came in. Jennifer called to our offices on the 19th of November 2007. The affidavit was signed on the 12th of December 2007. Nearly 3 weeks later. Okay? 3 weeks after she came to the bank. She was unsure if there would be sufficient funds to meet the direct debits on the joint personal account. The account balance was already over the assigned limit on the account, and on her instruction, I cancelled meaning all direct debits. Let me read that again. This is from Miss Terry McGeary at the AIB Bank on the 18th of December 2007. This is what she said. I refer to your correspondence dated 17th of December 2007. Jennifer called to our offices on the 19th of November 2007. She was unsure if there would be sufficient funds to meet direct debits on the joint personal account. The account balance was already over the assigned limit on the account, and on her instruction, I cancelled on direct debits. What did she say? I say he has cancelled all direct debits necessary for the running of the household here in Ireland. What did Terry McGeary say? On her instruction, I cancelled on direct debits. I advised Jennifer that I was going to call you and advise you that all direct debits were now cancelled. I telephoned you and you confirmed that all direct debits were to be cancelled. Well, what I meant was, you're going to cancel the direct debits. There's nothing I can do about that. So I confirmed that all direct debits are to be cancelled because there's nothing I can do about that. You have every right to do that. That's how the conversation went. Your fax dated 19th of November confirmed cancellation of all direct debits and check stops until such time as the overdraft is brought back under the limit. Meaning, I sent her a fax to say that I understood that all direct debits and all direct debits would be cancelled and all checks would be stopped against that account. I understood that it had been stopped, not I stopped them. I hope the above is to your satisfaction. Yours sincerely, Terry McGeary. There you go. Jennifer lied under oath in order to slander me, in order to blacken my good name. She lied under oath on an affidavit. That's what she did, and the evidence is right there in front of you, and you can question her as much as you like. If she remains silent, she accepts it. 13. Principal has not seen or been presented with any material fact or evidence that show respondent nor any of her criminal associates in the legal fraternity had any lawful right to close his bank accounts, relocate his children, deny him access to his children, demand money with menaces of kidnapping his children, threats of incarceration and seizure of his property, and right to lie under oath to discredit principal and slander principal for purposes of personal gain, and believes sincerely that none exists. Okay, that's what I say. Now, I have signed it. It's dated the 11th of March 2010. It was witnessed because there were no notary publics willing to deal with this stuff in England. And I introduced this notice of intent and proposed remedy. Based on the fact that respondent has been uncooperative for a period of more than 2 years with respect to the crimes committed against principal, the following is the intent of the principal and the proposed remedy. Principal insists that respondent provide proof of claim as follows. 1. Respondent to provide proof of claim that she had any lawful right to remove €18,000 from the company account of Instant Business Intelligence and to place that amount in her own private account, thereby depriving principal of his property. 2. Respondent to provide proof of claim that she had any lawful right to relocate the children of the principal against his written and communicated non-consent. 3. Respondent to provide proof of claim that she had any lawful right to demand money with menaces of kidnapping of principal's children, closure of his bank accounts which caused him to be impoverished, and collaboration with criminal elements in the legal fraternity to achieve these outcomes. 4. Respondent to provide proof of claim that she had any lawful right to make false statements under oath in order to discredit and slander the principal so that she could, in collusion with her criminal colleagues, to personally gain from such false statements under oath. Should the respondent be unwilling to produce proof of claim to the above, she will be charged with 1. One account of common law theft for the removal of funds from Instant Business Intelligence bank account, 2 counts of kidnapping the children of the principal, 1 count of extortion by way of demanding money with menaces, 2 counts of perjury for knowingly making false statements under oath. That's what she stands accused of. Should the respondent be willing to defend herself of these alleged crimes, the principal shall, at his earliest convenience, impanel a court de jure and present facts of the matter to the court de jure. The court de jure will decide the innocence of guilt along with what penalty of incarceration, if any, to impose on the respondent for these alleged crimes. Should the respondent be unwilling to provide proof of claim within 10 days of date of this notice, the principal retains the right to issue a default judgment of guilt for these alleged crimes. Should the respondent be unwilling to defend herself for these alleged crimes, the principal shall, at his earliest convenience, impanel a court de jure and present facts of the matter to the court de jure. Since the default judgment will be guilty of verdict on all 6 counts, the court de jure will only decide what penalty of incarceration, if any, to impose on the respondent for what will be accepted as crimes and what will be accepted as guilt from those crimes. It is the principal's advice to the respondent that these are serious crimes for which there is ample proof. A decision to refuse to mount a defence will leave the jury with no option but to determine what punishment to levy without the benefit of a defence. Principal notes that respondent has a right to confront her accuser, not an obligation for the accuser to wait until that right is exercised. A right not exercised is waived. Principal reminds the respondent that silence is considered acceptance and agreement. Signed by yours truly, the 11th of the 3rd, 2010. This concludes the reading of the file Notes of Crimes Committed 01 public into the public record and into this affidavit. Thank you very much for listening. And this begins the reading of Item 9, Notice of Crimes Committed 02 public, which has just the addresses and emails, addresses and signatures of people crossed out. Of course, the original is available for the jury members in confidence. Now, I just finished the reading of Item 8, Notice of Crime Committed 01, which was in March 2010. This document was served on the 15th of October 2010, which was exactly 3 years after Jennifer and I agreed to divorce, hence the date that it was sent. Okay, and I'm just going to go through this. This is very much similar to Crimes Committed 02. Okay, so I wanted to send a follow-up affidavit to Jennifer on the 15th of the 10th, 2010, to reiterate the crimes that she had committed. Okay, and this is now being read into the public record under oath, a penalty of perjury and full commercial liability. I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realized and free sentient man, my yes be yes, my no be no, do state the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to Jennifer Marguerite Toal, hereinafter known as a respondent. Affidavit with respect to crimes committed against Peter Andrew Nolan. Principal is of legal age and competent to testify. Principal has first-hand knowledge of the facts stated herein. Principal makes oath that on 11th of March 2010 he did create and swear an affidavit alleging a variety of crimes committed against him by the respondent. Principal makes oath that he did place his affidavit as registered mail in the Royal Mail. Principal makes oath that he has not seen any return from this registered mail and sincerely believes said mail was delivered. A certified copy of said affidavit is included with this package. Principal makes oath that on the 13th of August 2007, respondent wrote a cheque number 550043 against the company account for Instant Business Intelligence and deposited that cheque into our own account for our own purposes, being €18,000. 7. Principal makes oath that he at no time agreed to this transaction. 8. Principal has not seen or been presented with any material facts or evidence that show respondent had any lawful right to perform this transaction and believes sincerely that none exists. Principal makes oath that on or about the 31st of December 2007, Principal wrote to respondent and made clear his position that should respondent remove his children from the family home and relocate them to places unknown against the will of the Principal, then Principal would consider this action kidnapping and would prosecute respondent for any such action. 10. Principal makes oath that he is aware that at some time during the month of February 2008, respondent removed his dependent children from the family home and refused to disclose the location of Principal's children despite being politely requested to do so in writing by Principal. 11. Principal has not seen or been presented with any material fact or evidence that show respondent had any lawful right to relocate his children to places unknown and deny him access or contact to his children and believes sincerely that none exists. 12. Principal makes oath that respondent colluded with other criminals in the legal fraternity to close Principal's bank accounts and cast Principal into poverty such that Principal was reduced to begging for funds for food, shelter, lawyers' fees, travel and similar from family and friends. Principal makes oath that during this period of impoverishment that was forced on him against his will, respondent made demands for payment via associated criminals in the legal fraternity of the sum of €6,000 per month. Principal has not seen or been presented with any material facts or evidence that show respondent had any lawful right to petition for his bank accounts to be closed and impoverishing him, and believes sincerely that none exists. Principal makes oath that he is in receipt of an affidavit by respondent dated the 9th day of November 2007, and in that affidavit the respondent made the following testimony under oath. Quote, "The respondent, this principal, unilaterally withdrew the sum of €10,000 approximately from the party's joint account in Jersey without notifying the applicant, this respondent." Principal makes oath that the respondent was in possession of the following email on the 16th of October 2007 as follows, and that this email was retrieved from the respondent's Hotmail account. So 16th of October 2007. Well before November the 9th, okay? And I will read this into the record again in its entirety. If you want to skip forward, feel free to do so. Dear Mr. Messenger, thank you for your timely response. Whilst I appreciate that steps have been taken to prevent a recurrence, it still leaves me out of pocket, as I am not able to recover my half of the funds from Mr. Nolan. What steps is the bank willing to take to redress this situation? Please also forward me a copy of your formal complaints procedure. Many thanks, Jenny Nolan. And then from Steve Messenger. Dear Mrs. Nolan, as promised in my message to you last Thursday, I have now conducted a review of the chain of events which led to the recent transfer of funds from your joint account with us. Firstly, let me provide you with an overview of the situation. An instruction was received from your husband on 9th of October requesting the balance less $1,000 be transferred to your joint account with the Allied Irish Bank in Dublin. As we had previously been made aware of the possible separation of you and your husband, in line with the bank policy, your account had been marked to make sure all future transactions be completed only on receipt of joint instructions. On this occasion, our process was not followed correctly, which led to the funds being transferred without your authority, for which I sincerely apologise. Please be assured incidents of this nature are taken very seriously, and I have spoken to the persons involved and made them aware of the implications of their actions and the issues this has caused you as a result. I have also reviewed and refined our process to ensure this is not repeated in the future. I am very sorry for the inconvenience and distress we have caused you. Please do not hesitate to contact me should you require any further assistance with this matter or wish to discuss this in greater detail. So, as read into the previous record, it was a banking error that moved that money. I sent the instruction, but I didn't move it unilaterally. The bank moved it by accident. Okay? So, Mr. Messenger, dear Mr. Messenger, please excuse me sending you an email about this matter, but it seems the best option in light of the current postal strike. I'm writing to make a formal complaint about the handling of our account with you. Although it is a joint account, I believe Mr. Nolan had notified you that we were in the process of separating, and the account was subsequently frozen. As I understood that formal written permission would be required from both parties to reverse that action, I therefore assume no other written commission should be required for me to confirm this. You can therefore imagine my anger and distress, blah blah blah, to discover that Mr. Nolan was not only allowed by yourselves to remove almost the entire contents of the account on October the 9th, but subsequently moved the funds to a private account of his own where I am unable to access them. Yes, so you won't steal them because you just went into the company account and stole €18,000, right? At this point in time, she had already stolen €18,000, so she could not be allowed any access to any money because it was now probable that she would steal any such money. Although our account with you was relatively small, this is still a major inconvenience to myself and an added complication to be sorted out in our separation proceedings. If the majority of our funds had been held with you, this might have put myself and our children, children, let's talk about the children, in a very precarious position. I would like your assurance that this matter is being taken seriously and steps put in place to ensure a similar incident does not occur in the future. In the meantime, I will notify my lawyer that this has happened and take advice as to whether any recovery of the funds is possible. Yours sincerely, Jennifer Nolan. 16. Principal has not seen or been presented with any material fact or evidence that show respondent has any lawful right to commit perjury on an affidavit and believes sincerely that none exists. Okay. Principal makes oath that he is in receipt of an affidavit from respondent dated 12th December 2007, sworn at Phoenix House, and in that affidavit appears the following statement sworn under oath. I say he, meaning me, this principal, has cancelled all direct debits necessary for the running of the household here in Ireland, unquote. That's what it says. You can go and look at it. Principal makes oath that he at no time cancelled such direct debits and makes oath that he requested Ms. Terry McGeary to send him an email confirming that Principal had at no time requested direct debits required for the running of the house be cancelled. Principal makes oath that he merely accepted that since the overdraft had exceeded limits and there was no possibility of paying the overdraft due to the respondent's obstructive and destructive behaviour, then the bank had every right to stop the direct debits. Principal makes oath that he was informed of the cancellation of direct debits after the fact and accepted that there was nothing he could do about it due to the obstructive and destructive behaviour of the respondent. Principal makes oath that he received the following email from Ms. Terry McGeary of the AIB Bank on the 18th of December 2007. And that email says, Peter, I refer to your correspondence dated 17th of December 2007. Jennifer called to our offices on the 19th of November 2007. 19th of November 2007? Affidavit 12th of December 2007. She was unsure if there would be sufficient funds to meet the direct debits on the joint personal account. The account balance was already over the assigned limit on the account, and on her instruction, I cancelled on direct debits, meaning all direct debits. I advised Jennifer that I was going to call you and tell you, past tense, that all direct debits were now cancelled. I advised Jennifer that I was going to call you and advise you that all direct debits were now cancelled. I telephoned you and you confirmed that all direct debits were to be cancelled, like there's a choice. Your fax dated the 19th of November confirmed cancellation of all direct debits and check stops until such time as the overdraft is brought back under the limit. I hope the above is to your satisfaction. Yours sincerely, Terry McGeary. Okay, and Jennifer can try denying that if she wants. Again, on this count of perjury, Principal has not seen or been presented with any material fact or evidence that show Respondent has any lawful right to commit perjury on an affidavit and believes sincerely that none exists. Principal 19. Principal has not seen or been presented with any material fact or evidence that show Respondent nor any of her criminal associates in the legal fraternity had any lawful right to close his bank accounts, relocate his children, deny him access to his children, demand money with menaces of kidnapping of his children, threats of incarceration and seizure of his property, and the right to lie under oath to discredit Principal and slander Principal for purposes of personal gain and believe sincerely that none exists. Let's see Jennifer prove that. So you can see that I have signed it on the 15th day of the 10th month near London, England. You can see that it was witnessed, the signatures being crossed out. Now the notice of intent and proposed remedy. Based on the facts that 1. Respondent has been uncooperative for a period of more than 2.5 years with respect to the crimes committed against Principal, the following is the intent of the Principal and the proposed remedy. 2. Respondent has refused to respond to all efforts to request proof of claim that she has any right to perform the alleged crimes cited above, that these crimes are accepted as having been committed, and that Respondent has accepted her guilt for these crimes. This lawful notice hereby notices Respondent of the Principal's intent. Principal now formally and irrevocably accuses Respondent with the following common law crimes. 1 count of common law theft for the removal of funds from the Instant Business Intelligence bank account. 2 counts of kidnapping of the children of the Principal, 1 count per child. 1 count of extortion by way of demanding money with menaces. 2 counts of perjury for knowingly making false statements under oath. Further, due to non-response for proof of claim as to the lawful right to commit these crimes, Principal hereby lawfully notices Respondent that he finds Respondent guilty of said crimes by default judgment. Principal lawfully notices the Respondent that he will impale a de jure court and a de jure jury on the land commonly called Ireland, well, I'm going to do it in Australia, and will present evidence and affidavits to establish the guilt of Respondent in committing these crimes. Principal lawfully notices the respondent that he will ask the de jure jury to ratify the guilty default judgment for these crimes. Principal lawfully notices the respondent that he will ask the de jure jury to issue a remedy instruction as to the lawful remedy to be performed by respondent to bring justice to the principal. Principal lawfully notices the respondent that should respondent refuse to comply with the lawful remedy, that he will again convene a de jure jury in a de jure court and ask for an outlawry order to be issued for the respondent. Such an order will place the respondent outside the protection of the law. Principal lawfully notices respondent that should respondent choose to become an outlaw and live outside the protection of the law, that no peace officer or policy enforcement officers will be allowed to provide protection for the respondent. Further, no government department, nor any publicly traded company, nor any private person will be allowed to provide comfort or support to respondent as an outlaw. Any such person offering comfort or support to respondent will be charged with aiding and abetting a known outlaw. This is a crime, the punishment for which will be determined by another de jure jury. Principal lawfully notices respondent that should the outlawry order be issued, that he will also petition the de jure jury to order the Irish government, being the delegated representatives of the people of Ireland, to rescind citizenship, visas and passports that allow passage and residence of the respondent on the land commonly known as Ireland. The de jure jury will be asked to order the outlawed respondent to leave the land of Ireland and will order the government to comply with this order. Principal lawfully notices respondent that should respondent choose to become an outlaw, that he will insist that the de jure jury remove her from the land known as Ireland, as well as remove any and all property gained while in Ireland to donate to the poor of Ireland who could more properly use it. The de jure court and de jure jury will be impaneled at the principal's earliest convenience. Documents will be sent to the respondent by the court administrator. Sending documents by registered mail with return address will be considered good service of all documents so long as they are not returned. Should the respondent refuse to accept the registered mail for lawful notices, the People's Court will consider the respondent accepts the charges and guilty default judgment and accepts the will of the people expressed via the mechanism of a jury of 12 men making unanimous remedy instruction. The principal again advises respondent that these are serious accusations and serious default judgments, and that to refuse to respond to lawful notices is agreement by non-response and acquiescence. The principal again advises respondent that silence is not golden in this case, and that the apparatus of the state and legal system will be no defence against the People's Court of Ireland, as this court is superior to all state apparatus. A right not exercised is waived. Yours sincerely, you can see I've signed it and you can see I've dated it. Now when I wrote that in 2010, October 2010, remember this is over 2.5 years ago now, I've been waiting for this court to be convened. The people of Ireland have made it clear that they don't believe that women should be held accountable for their crimes. So this court is going to be convened by the Men's Business Association, the people of Ireland having waived their opportunity and right to put this person on trial by refusal to do so for, as I said, a period of 2.5 years. So now Jennifer is going to be put on trial by the Men's Business Association, using jury members from Australia on the basis that she was born and raised and lived the majority of her life in Australia. And so her peers, the people who are closest to being her peers, are Australians. So 12 honest men of honour and integrity who live on the land known as Australia are now going to put Jennifer on trial. This concludes the reading of Item 9, Notice of Crimes Committed 02, into the public domain and into evidence for this trial and this jury. Thank you very much for listening. Items 43 and 44 will be done together as well. Principal makes oath that I paid total fees of €21,000 to Pierce Neary of P.W. Tracy Solicitors in Dublin. The only reason I had to pay this amount was because of the perjury in respondent's affidavit of 2007-1109, and that makes her responsible for these fees. I require them to be repaid with interest and damages. I petition the jury to include this amount in the remedy instruction. Evidence that these fees were paid are included in the attachment's names as follows. 10. Pierce Neary, total fees. Item 44. Principal makes oath that I paid fees of 46,300 Australian dollars to Watts McRae. The only reason that I had to pay this amount was because of the perjury in respondent's affidavit of 2007-1109, and that makes her responsible for these fees. I require them to be repaid with interest and damages. I petition the jury to include this amount in the remedy instruction. Evidence that these fees were paid are included in the attachment named as follows. 11 Watts McRae total fees.pdf. And I will now include in the video stream a short video on those two fees to show the public that those fees were paid. Okay, items 10 and 11 are the total fees that I incurred in defending myself from this vicious, unprovoked, unwarranted and unwanted attack from my so-called darling loving wife. This is, as you can see here, from Pierce Neary. This is a bill from Pierce Neary. It is provided to you in an attachment. You can go scrolling down. Okay, and at the bottom you can see total received in full, 21,000 euros. Okay, total received in full, 21,000 euros. This means Jennifer owes me 21,000 euros plus interest. Okay. Watts McRae, 25th of November 2009. I asked Justin Dowd to please send me over a summary to the hotel of the costs incurred by Watts McRae. You see the number there, 46,306. That's how much money was spent with Watts McRae, 46,306. Naturally, Jennifer owes me that money and it has to be paid with interest. Thank you very much. That ends the reading into evidence of the fees that I paid due to the attack of Jennifer. Thank you very much for listening. Item 45. Principal makes oath that during this process he became aware that the government of Australia was a criminal cartel and was in league with the legal fraternity, which is why so many politicians are lawyers, the banksters, the police and the media. After all, the media suppressed this story from the time I took it to the Sydney Morning Herald in June 2008. The claim by such criminals as Justin Dowd is that common law does not exist and is not respected in Australia. Justin Dowd also claimed that the Magna Carta was not respected by the Australian Federal Magistrates Court. I have that in writing from Justin Dowd, the president of the New South Wales Law Society, remember? Unfortunately for Justin Dowd and all the other criminals in the family law system, a friend brought to my attention a speech by Robert McClellan, the then Attorney General. Robert McClellan clearly states that the Magna Carta is the foundation of the Australian legal system. Item 46. Principal makes oath that the Commonwealth of Australia is a registered legal entity on the US Securities and Exchange Commission. This makes the Commonwealth of Australia a uniform commercial code legal entity, just exactly the same as McDonald's or Burger King. It is a legal entity, the owners of which are unknown. If you go and read the Uniform Commercial Code like I did, one of the first items it says is that the Uniform Commercial Code must, repeat, must operate in harmony with the underlying system of law. This has two implications. One, the Uniform Commercial Code is not law. Okay, it is not law because it must operate in harmony with the underlying system of law. It is a code, not law. Two, that there is an underlying system of law which the Universal Commercial Code must be in harmony with. The entire speech made by Robert McClellan will now be read into evidence for this affidavit. I will make comments in the speech as appropriate as part of the testimony I am reading into evidence. If respondent wishes to rebut anything I say under oath and penalty of perjury, she is most welcome to. So now we will include in the video stream the speech by Robert McClellan. Now I will read into evidence a speech made by Robert McClellan when Robert McClellan was the Attorney General for Australia. So you see the logo there. This was taken off Robert McClellan's website, off the Attorney General's website. You can see that there. Okay. The speech was on the 20th of February 2009 at a Constitutional Law Conference, and you will see in this speech Robert McClellan clearly indicate common law and the Magna Carta is superior to the legislation of the Commonwealth of Australia, and it is the foundation of the legislation of the Commonwealth of Australia. So, Mr. Jury Member, I will read exactly what it says and I will make commentary during this presentation, but please remember who said this and when. This was Friday, the 20th of February 2009, 8:15. This was some 10 months before November the 26th, 2009, which was my appearance in the Australian Federal Magistrates Court. Okay? This 20th of February predated my 26th November meeting by 10 months. So this is what Robert McClellan said 10 months before you saw the video before the video was created in that court. So Robert McClellan says, "First may I acknowledge the traditional owners of the land we meet on and pay my respects to their elders both past and present." Other acknowledgements. Who said? Associate Professor Andrew Lynch, Gilbert and Tobin Centre for Public Law, University of New South Wales, Sir Gerald and Lady Brennan, Sir Anthony and Lady Mason, the Honourable Ian Callanan and Mrs Callanan, Justice Mitchell Gordon, Federal Court of Australia, Justice John Hayden, High Court of Australia and Mrs Hayden, distinguished guests, ladies and gentlemen. So, a Justice of the Federal Court, a Justice of the High Court, people who should know what the law is around this place, right? And this is what he said. As many of you will know, the Australian government, through a committee of eminent Australians, is currently consulting the people of Australia on the recognition and protection of human rights. With limited exception, our Constitution does not recognise individual rights, freedom or guarantees. In Kruger v. Commonwealth, 1997, Justice Dawson said, quote, "Those who framed the Australian Constitution accepted the view that individual rights were best on the whole left to the protection of the common law and the supremacy of Parliament. Thus, the Constitution deals almost without exception with the structure and relationship of government rather than with individual rights," unquote. Okay? Justice Dawson in Kruger v. Commonwealth, 1997, said, "Those who framed the Australian Constitution accepted the view that individual rights were best left to the protection of the common law." Okay? Which is the jurisdiction that I claimed. And the Constitution deals almost without exception with the structure and relationship of government rather than with individual rights. So when David Dunkley was talking about inalienable rights is an inanity, this is what he's talking about. He's talking about common law, and he's talking about the Magna Carta and the Bill of Rights of 1688. He then goes on to say, nevertheless, in dealing with the structure and relationship of the government, the Constitution does protect some fundamental individual rights. These rights are said to arise from, quote, silent constitutional principles, unquote, that are part of our public heritage. That constitutional heritage includes the English constitutional instruments, Magna Carta and the Bill of Rights. Okay? So these rights are said to arise from, quote, silent constitutional principles that are part of our public heritage. That constitutional heritage includes the English constitutional instruments, the Magna Carta and the Bill of Rights, 1688. Let's remember who's saying this. Robert McClellan, February 20th, 2009. Attorney General. Okay? That is who said Magna Carta and Bill of Rights. Tonight, and so you, Mr. Jury Member, and you, the general public, if you bother to actually investigate and review the evidence before you make up your mind about this, you have in front of you the Attorney General of Australia telling you that the Magna Carta and the Bill of Rights is in force and protects individual rights in Australia according to the Australian government. Okay? That's what he told you. Tonight I would like to reflect on how the first of those English constitutional instruments has had a profound impact on the development of fundamental rights, namely the right to due process, and he means of law, and the right of citizens not to be arbitrarily deprived of their property. Okay, the rights of citizens, now citizens is another deceptive term, but the right of citizens not to be arbitrarily deprived of their property. What did David Dunkley do? He made up rubbish that he pulled out of his arse and he arbitrarily deprived me of my property. That's what he did. Okay? And you saw it in the court order. He goes, oh, I'm going to vary this by 22% on the basis of probabilities. Not evidence, the basis of probabilities. That's what he said. Okay? So, namely the right to due process and the rights of citizens not to be arbitrarily deprived of their property. In doing so, I will endeavour to avoid what one writer has described as the unsatisfactory compound of, quote, a mixture of legal dogma and legal history. So Magna Carta, Robert McClellan says, Magna Carta is generally regarded as the origin of that principle which underpins the Westminster system, the rule of law. Its significance to Australia is recognised by the fact that a copy of the Charter is displayed in our federal parliament. As an aside, according to modern values, it could be argued that the Charter is voidable because on the 15th of June 1215 it was obtained under clear duress from King John. But Magna Carta was subsequently confirmed by 7 kings and its principle has been repeated from generation to generation. There can be no doubt that the barons, clergy and foot soldiers who so pressured King John intended the document to be of great significance and intergenerational in its impact. Chapter 1 sets out that King John granted to all freemen, quote, all the underwritten liberties to be had and held by them and theirs and of us and our heirs forever, unquote. Forever, unquote. In chapter 61, the king also committed that he shall, quote, procure nothing from anyone, directly or indirectly, whereby any part of these concessions and liberties might be revoked or diminished. And if any such things has been procured, let it be void and null. Not a bad job of entrenching, I must say. So, David Dunkley was representing the king, the government. And the Magna Carta says, the king also committed that he shall, quote, procure nothing from anyone, directly or indirectly, whereby any part of these concessions and liberties might be revoked or diminished, and if any such thing has been procured, let it be void and null. Okay? So what David Dunkley did is void and null according to the Magna Carta, which he has to abide by. Okay? The charters have had significant success. Their intentions have been fulfilled, at least in respect of those matters I have mentioned. The due process of law and resistance to arbitrary deprivation of property. Well, not in my case, obviously. Due process of law. Unquestionably, the most significant clause of Magna Carta is contained in Chapter 39, which has been interpreted as saying, quote, No free man shall be taken or imprisoned or diseased or outlawed or exiled or in any wise destroyed, nor shall we go upon him nor send upon him, but by the lawful judgment of his peers or by the law of the land. Quote. That's Robert McClellan saying that. Was I diseased of my property? Was I in any wise destroyed? Was I set upon without lawful judgment of my peers? I think so. Over time, the phrase the law of the land evolved to become due process of law. The earliest formal use of that term is in a statute in the year 1354-28 with Edward III, which provided that no person should be condemned without first being brought to answer by due process of the law, or in Norman French, due process de lire. There has been extensive writing and indeed controversy about the evolution of this crucial term. But I think it is fair to say that the evolution of the phrase is significant because it became more than a mere descriptive of law of the land. Instead, due process became a fundamental concept and principle which has both informed the development of the law and tempered its application. So, was I afforded the due process of law? And the answer is, of course not. I was not afforded the due process of law. You have got the video in front of you and you can answer yourself, was I afforded the due process of law? And you can only answer no to that, because I asked many times over for the agreement to step onto the ship and to negotiate the situation, discuss the situation, and I was denied the opportunity to step onto the ship with all my inalienable rights intact, therefore being denied due process of law. So now here we are 3 years later, and we're getting due process of law, right? In the Australian context, in R versus McCullough, ex parte Ratu, Justice Murphy specifically credited Magna Carta as a foundation of natural justice and due process, saying, quote, "The doctrine of natural justice is not a modern development. It is traditional in most English-speaking countries. It is an aspect of due process traceable in English law, at least back to the Magna Carta," unquote. Right? That's an Australian justice. In Abner versus Official Trustee in Bankruptcy, 2000, Gleason, C.J., McGower, and Hain, J.J., said, quote, "Fundamental to the common law system of an adversarial trial is that it is conducted by an independent and impartial tribunal. Perhaps the deepest historical roots of this principle can be traced to the Magna Carta," unquote. You, my dear sir, sitting on this jury, are part of an independent and impartial tribunal. You know, this is the fundamental to the common law system of adversarial trial is that it's conducted by an independent and impartial tribunal. That's what you are sitting on this jury. Okay? There remains debate as to whether there is an implied constitutional right to a fair trial in Australia, at least at a federal level, but it is nonetheless arguable that a fundamental principle of due process is integral to Australia's constitutional heritage and the development of Australian jurisprudence. Okay, well, I don't think there is a debate as to whether you have a right to a fair trial in Australia. I don't think that's up for debate, and if you on the jury say it's not up for debate, then it's not up for debate. 14. It might seem that at a deep level in the court's jurisdiction that Chapter 3 of the Constitution, the separation of judicial power, presents a barrier to any, quote, bill of attainder or quote, bill of pains and penalties. Even at state level, it might be seen in concerns about legislation pertaining to the Parliament to direct the detention of a person for the purpose of punishment when their guilt or innocence has not been determined by a court. And it might be seen in the determination to uphold the discretion of courts to stay proceedings where an unfair trial would otherwise result. 15. Interestingly, the principles of Magna Carta are echoed beyond the criminal jurisdiction. In Groves versus the Commonwealth in 1981, the High Court determined that a member of Australia's armed services could not be prevented from pursuing an action for negligence against the Commonwealth in circumstances where he was not involved in armed conflict. This was, the court said, because he may not have the benefit of Chapter 29 of Magna Carta, justice to him can be denied by the courts. Unlike the rest of the community, he is excluded from what Sir Edward Coke described as the right of every subject, that he may, for injury done to him by another subject, take his remedy to the course of the law and have justice and right for the injury done to him. Okay? So Magna Carta was reflected into the military area. Now 16, deprivation of property. Okay. Australian courts have also recognised the historical foundations of Australian constitutional bulwarks against arbitrary deprivation of property. Well, not in David Dunkley's arbitrary Australian Federal Magistrates Court, it's not. Okay? 17. In the Communist Party dissolution case in 1951, the High Court said that as at the date of the Constitution, quote, the King had no power by the exercise of his prerogative to dissolve bodies corporate or unincorporate or forfeit their assets to the Crown or to deprive his subjects of their contractual or proprietary rights. Such an action on this part would have been contrary to Magna Carta and the subsequent acts reaffirming Magna Carta referred to in Halsbury's Laws of England, 2nd edition, volume 6, page 450. Okay, that's what that case said. That is not to say, as was made clear in the Communist Party dissolution case, that a person or entity could not be deprived of their property by a valid law of the Commonwealth Parliament. However, as was explained in Clooney's Ross versus Commonwealth 1984, quote, an executive power of acquisition of land for a public purpose is different in nature to a legislative power of a national parliament to make laws with respect to the acquisition of land for a purpose in respect of which the parliament has power to make laws. See Magna Carta, clause 29, unquote. The exercise of legislative power under Section 51 of the Constitution is, of course, conditional on just terms compensation. That precondition, I would argue, stems from the victory that the barons and clergy and people of England had over their monarch on the 15th of June, 1215. Let me read that again. The exercise of legislative power under Section 51 of the Constitution is, of course, conditional on just terms compensation. That means if David Dunkley steals my property, pretending to use the Constitution, he must compensate me on just terms. And that those just terms are 1 million ounces of gold. That's what he agreed to, and you heard him say that. The issue of proprietary rights of the individual is interesting because it is an area that a possible merging of the principle of Magna Carta and the primary international human rights instrument, the Universal Declaration of Human Rights, can be detected. And I just want to point out the Australian federal government does not consider itself bound by the Universal Declaration of Human Rights, regardless of what they tell you. They have not agreed that they are bound by the Universal Declaration of Human Rights. It's only been 60 years, but they haven't wrapped that into the Australian Constitution yet. Okay? For example, in Newcrest Mining 1997, Justice Kirby referred to Article 17.2 of the Universal Declaration, which provides that, quote, no one shall be arbitrarily deprived of his property, unquote. I was arbitrarily deprived of my property by David Dunkley. Okay? And here's Justice Kirby in 1997, citing the Universal Declaration of Human Rights, which provides that no one shall be arbitrarily deprived of his property. His Honour described the roots of Article 17 in the following terms, quote, whilst this article contains propositions which are unremarkable to those familiar with the Australian legal system, the prohibition on the arbitrary deprivation of property expresses an essential idea which is both basic and virtually uniform in a civilised legal system. Historically, its roots may be traced as far back as the Magna Carta 1215, Article 52, of which provided, quote, to any man whom we have deprived or dispossessed of lands, castles, liberty or rights, without the lawful judgment of his equals, we will at once restore these. So let me quote the Magna Carta, Article 1215, Article 52 again, which provides, quote, remember David Dunkley took my property arbitrarily on the basis of what he called probabilities, not evidence, quote, to any man whom we have deprived or dispossessed of lands, castles, liberties or rights, without the lawful judgment of his equals, we will at once restore these. Quote, you people I am presenting this to are the jury. You are bound by the Magna Carta. This jury is formed in common law, and the Magna Carta says, okay, and I'm going to repeat it again because you've got all this evidence in front of you. The Magna Carta says, to any man whom we, meaning the king and his agents, meaning David Dunkley, whom we have deprived or disposed of lands, castles, liberties or rights, meaning lands and castles, meaning money, my house, a man's house is his castle, they stole my house, liberties or rights, without the lawful judgment of his equals, we will at once restore these. Was I given the lawful judgment of my equals? No. Therefore, they are bound by the Magna Carta to we will at once restore these. You, the jury, are bound by the Magna Carta to at once restore these things that I had stolen from me, unless you, David Dunkley, can prove that he had the right to do this. Absent any proof, you are bound. You have no choice. You are bound to issue remedy instructions to restore my property to me. Okay? 21. His Honour adopted similar reasoning in Malika Holdings Proprietary Limited versus Stretton 2001, where he said that, quote, the Universal Declaration of Human Rights, Article 17, like the Magna Carta 1215, Clause 52, treats as fundamental the rule against arbitrary deprivation of property, unquote. Some may say we are seeing a merging of ancient rights and ancient constitutional principles with developments in international law. Just as an aside, I wonder if the people in Cyprus are reading this, right? These ones about to have their bank accounts arbitrarily looted. 23. It is not my intention to enter that debate, save insofar as I will invite you to consider the words of Justice Brennan in Mabo versus Queensland No. 2, where he said, quote, the common law does not necessarily conform with international law, but international law is a legitimate and important influence on the development of the common law, especially when international law declares the existence of universal and fundamental rights, unquote. I appreciate that there is a difference of opinion as to the extent to which fundamental international human rights principles have influenced and continue to influence the development of the common law. The same common law that Justin Dowd claimed was not in force in Australia, right? The president of the New South Wales Law Society claims this common law that the Attorney General is talking about, that all these justices are talking about, was not in force in Australia. That shows you how criminal Justin Dowd is. I would suggest, however, that this will inevitably be the subject of ongoing academic and adversarial debate. In particular, our friends across the Tasman are also engaged in the debate. For instance, Cook P, as he then was, of the New Zealand Court of Appeal, said that it is, quote, the duty of the judiciary to interpret and apply national constitutions, ordinary legislation, and the common law in the light of the universality of human rights, unquote, and the common law. Conclusion, 25. Given this controversy, and in closing, I will leave you with a question to which there will no doubt be a range of responses around the room. The question is, should the Parliament by legislative action or the Executive by administrative action or practice do anything to guide or influence that evolution of this important debate? An interesting challenge for Justice Brennan's son, Father Frank Brennan, who is presently chairing the government's National Human Rights Consultation. I look forward to hearing what you and all Australians have to say on this issue. And it ends. Well, I can tell you what I have to say on this issue, Robert McClellan. I issued notices to you about the crimes committed against me in December 2009 when you were the Attorney General. Given this speech and the fact that I was arbitrarily deprived of my property, one wonders, Mr. Robert McClellan, why you did not take an interest in my case. Anyhow, I'm sure you'll take an interest in my case when I put you on trial. All right? So this concludes the reading into evidence of Robert McClelland's dinner speech from the 20th of February 2009. Thank you very much for listening.